Please rise. The justices of the Appellate Division, Supreme Court, First Department. He who opens transacting business with the Appellate Division. Draw near, give your attendance, and it shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have about 4.5 hours of argument time requested today. I therefore request that you only ask for the time that you need. We are familiar with the briefs and the records, and if we need more time, we will continue to ask questions after the time is up. People versus Ali, appellant. Nobody here? Okay, that is submitted. Brooke versus Yang, and Justice Moulton is recused in that case. Appellant? Respondent? I'll give you 7, 1, and 6. West 125th Street Realty versus Chosen Realty. Appellant? Are you respondent? Do you wish to submit? Three minutes. Cruz versus Heights Broadway, appellant.
Request 5 minutes and 2 minutes rebuttal.
5, 2, and 4. People versus Jamel is submitted. Small versus, what? Okay, it's uncontested, though. No one's really opposing it.
Yes, Your Honor, just here to support any questions.
What?
Just here to support any questions about the case.
I don't think we're going to have any questions, since the relief you're requesting is not opposed. Is it? Yeah. Okay, submitted then. Small versus Estate of Uri Landsman, appellant. Is appellant not here? Do you wish to submit? Sure, 2 minutes. 57th and 60th Street versus State Bank of Texas, appellant. Respondent? 6, 2, and 5. People versus Pettiford, appellant. Respond. 5, 1, and 4. Iberdrola Energy versus MUFG Union Bank, appellant. Respondent.
Your Honor, we request the same, but I think it would be far less.
Okay, I'm going to give you 8 and 1 and 8 and 1. People versus Tureen Williams, appellant. Submitted. Hammond versus Equinox Holding, appellant.
Appellant request 7 and 3, Your Honor.
Respondent.
Your Honor, request 5 and 2.
7 and 1 and 5 and 2. Kwong versus the Zoo is submitted, and DeWald versus S&P Associates is submitted. Brooke versus Yang, and Justice Moulton is recused on that matter.
Good afternoon, Your Honors, and may it please the Court. My name is Jacob Tabor of Perkins Coie LLP. I represent the Uber appellants. I rise to introduce my colleague, Michael Houston, of the Bar of the District of Columbia, and ask that he be permitted to argue the appeal today.
Go ahead.
May it please the court, I'm Michael Houston of Perkins Coie on behalf of the defendant appellant, the Uber entities. The plaintiff admits in this case that click-wrap agreements are generally enforceable under New York contract law. And that's because when a digital user is given notice through a reasonable opportunity—
This court, though, hasn't addressed that issue yet. Is that correct? Has the First Department actually made a ruling on click-wrap agreements yet?
I think that the court has the most direct on-point authorities from this court, Your Honor, are the Quill decision, in which the court implicitly, and expressly referred to adopt the reasoning of the Teja v. Facebook case that was from the Southern District of New York. And in this court's recent decision in Castro, it also specifically it endorsed the reasoning of the Wu case from the Supreme Court. And in both cases, both Wu and Teja endorse the enforceability of click-wrap agreements. And again, I think both this court in Quill and then this court in Castro endorse that reasoning. And that's because a click-wrap agreement that affords a user reasonable notice of the terms on which the contract will be bound, and then expressly requires the user as a condition of using the service to agree to those terms, provides at least reasonable notice. Now, I think
What about the decision in Zambrano, which I know goes the other way? What's your response to that?
Certainly.
Since we haven't issued our definitive decision yet.
Certainly, Your Honor. Zambrano, I think, is a clear outlier. The consensus weight of authority that has applied both New York contract law and the law of other states. That would be decisions, again, of this court, of other appellate departments, of the Supreme Courts, of the Southern District of New York, the Second Circuit in Meyer. When you look at the wide range of courts that have considered click-wrap agreements very similar to or identical to this one, I think the overwhelming consensus is that these are enforceable. And Zambrano, what I think is notable about that case, is that it did not even really purport to apply the inquiry notice standard that this court has made clear governs. Zambrano talked about the way that society works today. It was based on the Supreme Court's intuitions about—
Does the fact that this is a 2019 accident and the click is done by the plaintiff on 2021, does that impact on your position that it has a retroactive effect?
No, Your Honor, because the terms of use to which the plaintiff agreed could not be more clear, that they would govern all disputes that the plaintiff may have with Uber, including disputes, and this is a quote from the record, arising before or after the plaintiff agreed to those terms. That's on page 79 in the record. The arbitration provision also broadly recurred to the fact that the plaintiff would be required to arbitrate any dispute with Uber. I think when you combine those two things, the plaintiff here really could not have misunderstood.
Also, was that portion that you just read, was that highlighted in any way? Because that's significant, right? One would think that if you're clicking on an agreement or you're consenting to something, that it would work going forward, right? I don't think the average user would expect that by clicking on that agreement that they're giving up a right for a past incident.
Well, Your Honor, respectfully, I don't think that's quite right. I mean, I think we had an obligation to notify the user of what the terms were, but the terms of use are expressed. It's not expressly highlighted, but it's written in plain English. And that is, I think, the critical feature. There's nothing deceptive about this agreement. There's nothing that is hidden in legalese. It says you agree to arbitrate, both you and Uber. It's a bilateral agreement. It binds Uber in exactly the same way. It's not one-sided. And both parties agree that they will arbitrate all disputes that they may have, whether they arose before or after the terms of use were agreed to. I'm sorry, I just want to correct. I said it was on 79. It's on page 82 of the record, is the phrase where that phrase expressly appears. And again, this court has held in other cases that where you have a broad arbitration agreement that provides that any dispute will be subject to arbitration, that the breadth of that language, any means any, encompasses disputes that may already exist. I also think it's just notable, Your Honor, that the plaintiff had not initiated this lawsuit. Certainly the accident had occurred, but the plaintiff had not filed the suit when he was presented with this.
You beat that by 9 days.
I'm sorry, Your Honor, I couldn't quite hear the question.
You beat that by 9 days. The action is commenced on February 29th, is it not? And she does this click wrap on February 20th.
February 20th is the correct. Your Honor has the sequence right. Although, frankly, even if the lawsuit had been initiated, I confess I don't think it would have made a legal difference. But you're absolutely right. At the time this plaintiff signed this agreement, there was no claim.
Would it make a difference had the action been commenced I mean, could you go to her and in this manner get it to, while she's represented by counsel, get her to give up legal rights?
Well, I think the thing that I think is distinct in the actual facts as opposed to Your Honor's hypothetical is we didn't go to the plaintiff. The plaintiff came to Uber and said, I would like to access Uber's service. Uber said, we're willing to provide you with that service, but there are conditions that apply. One of those conditions is if you want to use our service, you have to agree to arbitrate all disputes, including...
That was what happened initially, but when the 2021 contact came up, wasn't she already a member of Uber, and Uber came back to her and said, we've changed the terms and conditions?
Yes, Your Honor, that the plaintiff already had an Uber account, but I don't think that matters because the...
Oh, but she didn't initiate that contact, did she?
Respectfully, I would disagree with that, Your Honor. The plaintiff opened the Uber app and said, I'd like to enter a transaction with Uber. I'd like to do business. The plaintiff has done business with Uber in the past. That's true. But, each occurrence is a new incident, just the way you visit a restaurant. You've visited a restaurant before. When you come back, it might be a different service. So I think the critical point is when the plaintiff came to Uber and said, I'd like to access the Uber service, Uber said there are conditions on our use of that service. And one of them is we're going to agree, both of us will mutually promise to each other that we will arbitrate all disputes that we have. It has, of course, been held repeatedly by the Court of Appeals that there's a strong public policy in this state favoring arbitration.
Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I think I need to start, what's really important is to start with defendant's burden. As you know, in a motion to compel arbitration, it's akin to motion for summary judgment. And here, we don't know, this record is not clear as to which terms the plaintiff allegedly assented to, and here's why.
But your colleague who represented the plaintiff below acknowledged in his papers that plaintiff had agreed to the terms that were in effect as of January 2021.
Now, if you look at 79 of the record, and the plaintiff signed up in 2016, right, and then assented in 2021. The record is unclear as to which terms, the terms that were submitted on this record. If you look at the affidavit of Busio, he says that my client assented on April 17th, okay, of 2021, or April 14th of 2021. If you look at 73 of the record, he says plaintiff clicked the box to confirm on April 17, 2021, and I'm attaching.
I'm aware of that. I'm talking about the affidavit by plaintiff's counsel, Mr. Perlman, who says the update to on page 234 of the record, this update to the terms of use on the rideshare application on January 18, 2021 contained a click wrap agreement. So he was acknowledging that the click was made in January of 2021 and concerned an agreement then in effect, not the April one.
But if you look at, I understand that's the plaintiff's affirmation in opposition. If you look at the affidavit
I understand about the affidavit, but it seems to me that once plaintiff's counsel agreed that your client had agreed to the January terms
But I don't think he said that. I think he said that the January terms were allegedly put into the record, but there's a conflict, and he did expose the discrepancy as to Busco's affidavit that says, well, he clicked on in April and attaches as Exhibit C the April terms. So my position to you is we don't know what terms he agreed to. If he agreed in February of 2021, he couldn't have agreed to the April terms. And
I understand that, but given that plaintiff's counsel agreed in his affirmation that it was the January terms that your client agreed to, I just don't see why that matters anymore. Okay, I was troubled by that and spent a lot of time figuring it out and then realized that.
Well, I think whether what's attached is the April 2021 terms or the January 2021 terms, I would like to point out the fact that in Castro, your court, and you actually sat, and Judge Kern sat in Castro, And you held that the December 2017 terms was held to be not sufficient for inquiry notice or assent. And those terms, when compared to whatever's attached here, and that's at 81 of the record, they're the same terms.
No, counsel, they're not. I mean, we carefully reviewed the record in that case and this case, and they're completely different terms. And in essence, that was not a click-wrap agreement, what was submitted in Castro, and what's submitted in this case is a click-wrap agreement. They're completely distinguishable in the submissions to the court as to what was presented to us and the detail about the terms of the agreement.
The terms of the arbitration and potentially the delegation is a little bit different, but the concept of retroactively agreeing and foregoing your rights to a jury is similar. And so that's why I'm pointing out
That was not the basis for our holding in Castro. The basis for our holding in Castro was that the terms that were submitted there that constituted the agreement to arbitrate was not a click-wrap agreement.
Right.
Whereas here, they were
I
a
understand.
click-wrap agreement. So here, we are squarely being faced with an issue we were not being faced with in Castro, is whether or not these click-wrap agreements are enforceable.
I would just, okay, I understand that's a browse wrap. I understand the difference. But I would just ask you to look at 77 of the record then. If you're going to look at the pop-up, I would like to tell you, I would like to explain as quickly as I can in my time left to show you why this isn't sufficient.
What else is it that you would have required of the defendants in order to be able to hold your client to that arbitration agreement? What is it that they didn't do that they shouldn't have done in order to accomplish the purpose which they sought to accomplish?
Because if you look at 77 of the record, this pop-up agreement isn't sufficient to give inquiry notice or assent. It doesn't set forth, I mean, there's no hyperlink as the arbitration agreement. If you're going to ask a user to retroactively apply an arbitration agreement.
Could you get to service without agreeing?
I'm sorry?
Could you get the Uber service without agreeing?
You have to click, no, you have to say that you've reviewed it.
You had to say you agree.
Had to say you
know
agree.
you're agreeing to something.
Correct. But my position to you is that with regard to whether this is sufficient for clarity and conspicuousness, as we know is the standard under New York, this just says we're updating our terms. It doesn't say what the terms are. It doesn't mention arbitration. It doesn't say we're conveying.
Didn't it have a hyperlink to those terms?
It does have a hyperlink to the terms, but it doesn't set forth the real essence of the terms, because if you look at the agreement at 81 of the record, it has other things. It's not just arbitration. It talks about payment. It talks about behavior in the Uber. It talks about other things, and our position is this.
Is that not enough to put someone on inquiry notice saying that the terms have been updated and therefore there is a hyperlink to these terms? Maybe you should click on it.
I would say it's not, because it doesn't set forth the fact that two things. Number one, doesn't say we're updating our arbitration agreement. So if you look at when he registered, which by the way, we have no idea what terms were in effect when the plaintiff registered. So if you're updating something that was potentially unenforceable, and now you're giving a pop-up agreement that doesn't even say, listen, you better look at this. This is really important. It's affecting your rights to a trial by jury, and this is applying retroactively. It should be in the face of the pop-up. You shouldn't have to. If I could just tell you.
No, thank you. But does anyone have any more questions?
I have two questions.
Sure.
So I don't understand why this provides less information to the consumer than the typical credit card agreement that you get periodic updates of, that's pages and pages of paper with small type that have been found to be just fine. Why is this less information than that is?
Well, if you look at the
Or less informative, rather.
Sure, I'm sorry for interrupting. If you look at 2A, the arbitration agreement at 82 of the record, it talks about it being retroactive as to claims or things in controversy. It doesn't talk about whether it bears on a pending lawsuit, whether you've engaged counsel. It's not clear. You have to go to 2 to 3 pages after you click the terms of use to even get to what they're saying about arbitration. So our position is, this is serious. You're giving up your right to a trial by jury. You're also dealing with a retroactive effect. That's something that happened 2 years ago. And my position to you is that this is not, there's no link to meaning what happened to plaintiff in 2019 in his accident. It's not related to this. There's no causal link to this agreement.
That leads to my next question, which is that it seems to me that if your client knew he had a pending claim against Uber at the time that this showed up in his inbox, and if he was concerned about its impact on his pending claim, he could have not signed it and chosen not to take a ride with Uber that day. I mean, it's not like a situation, I mean, he knew that he had a claim. He could choose to take an Uber or not. If he hadn't clicked on it that day, he could have proceeded with his old claim in court as opposed to arbitration, right?
Well, my position is that here, if you look again at the pop-up page, it doesn't really provide an option to what you do if you're going to opt out. It doesn't give you an opt-out.
Just let me make sure I
Sure.
understand your position. Do you agree that if he hadn't clicked on that and chosen not to take an Uber that day, he would have still been able to proceed in court on his old claim, right?
On his old claim?
On his existing claim, on the 2019 claim?
I'm
There was
not-
nothing that before this day that prevented him from going forward in court on the pre-existing 2019 claim, right?
Well, I'm not sure, because I don't know what the agreements that were in effect when this accident happened and when he registered. That's my point. It's not in the record. It's their burden. This is like a motion for summary judgment, and there's no evidentiary proof as to what he agreed, what the agreement said when he registered, when he apparently clicked consent, and at the time of the accident. And just before, can I just do one more?
No, thank you. Do you have any more questions? Thank you very much.
Thank you for listening.
Thanks for humoring me. Thanks for humoring me.
Thank you, Your Honor. Just a couple of quick points. On retroactivity, I think it's important to note that the parties expressly delegated the resolution of that issue to the arbitrator. So it wasn't for the Supreme Court to resolve. It just goes to the scope of the arbitration. That's a separate portion of the arbitration agreement. The Supreme Court of the United States has made clear that that type of delegation clause is fully enforceable. That's Rent-A-Center and Henry Schein v. Archer and White Sales. I think for that reason, any questions about whether this arbitration agreement uncovered a retroactive dispute that it was already in existence has to go to the arbitrator, not the court. On the click wrap, I think it's important to emphasize how much of the modern economy is built on the premise that click wrap agreements are enforceable. I would really respectfully urge this court not to make New York an outlier among all the jurisdictions of the United States that have addressed similar terms and that have repeatedly held that click wrap agreements are enforceable. The courts, many courts applying New York law that have held that click wraps are enforceable. For the court to say that a click wrap is not a sufficient way to form a contract would, I think, be extremely destabilizing, not just with respect to arbitration, but with respect to all different kinds of contractual terms. The bottom line point is that anybody who wanted to read the terms of this contract had an easy opportunity to do so by clicking on the hyperlink. Thank you.
Very much. West 125th Street versus Chosen.
Good afternoon, Your Honor. May it please the court? My name is Michael Urshowski of Urshowski Verstandig PLLC. I represent the plaintiff respondent, West 125th Street Realty, LLC. Given that the appellant has submitted their brief, I'm just going to limit to 2 points that I wanted to discuss concerning the reply. On page 6 of the reply, there's a statement that included in the telecom easement, there was a non-exclusive access easement, and that somehow the purchaser, my client, should have relied on that provision in the telecom easement. It's completely inapposite because it's granted in favor of the grantee under the telecom easement, which is not my client. In fact, the fact that my client, that this easement was granted altogether is the substance of the case. My client would be subject to allowing the grantee under the telecom easement to utilize other parts of the property. That's what that applies to. It's not something in favor of the plaintiff who owns the property, but it allows the other, the grantee of the easement to now go up to the roof through the rest of the property. It has nothing to do with the owner of the property. I just also wanted to address the fact that there are many allegations or statements in the reply that refer to Riverside Abstract, which is the title company, the potential claims that my client would have had, rhetorical questions, all these different statements that are just inapposite to the case that's at bar, which is simply a fraud case between the purchaser of the property against the seller of the property, which is Chosen, and all of these other factual claims discovery issues are simply the business of the trial court and not subject to the motion to dismiss that's the subject of this appeal.
Okay, any questions from anybody? Okay, thank you very much.
Thank you, Your Honor.
The next case is Cruz versus Heights Broadway.
May it please the court, my name is Dennis Ganine from the law firm of Keller O'Reilly & Watson. I'm appearing on behalf of the appellant 185th Operating today. I'm going to quote from you, for you, the trial court's decision from here. There remains on this record issues of fact as to whose duty it was to maintain the specific area of the sidewalk where plaintiff fell. The trial court took for granted that all defendants in this case could have been held liable under some duty recognized by the state of New York. With snow and ice cases, with slip and falls, there has to be either a contractual duty, a common law duty, or a statutory duty to be held
Counsel,
liable.
what about 185's voluntary snow removal? Did that give rise to any question about whether it caused and created the condition?
I'm sorry, you said 185s?
Yeah, your client.
185, okay, I apologize.
Did voluntary snow removal, and did that exacerbate a condition?
Right, so there's no evidence that 185th actually undertook snow and ice removal during the specific date in which there was both the leaking fire hydrant and a snowstorm the day prior, actually a few days preceding that. Additionally, there's no evidence that
Isn't there some evidence in the record, though, that it did engage in snow and ice removal in front of the premises, even if it didn't have any contractual obligation to do so?
Of course, they were volunteers at that point.
Right, but if they were volunteers, I think my colleague's asking if they were volunteers and somehow they made the condition worse or exacerbated, they could still be held responsible.
If there was actually some evidence that they did in this instance, that they did go out and they shoveled or they put de-icer down or whatever, sure, you can make a case that those actions did create or exacerbate the underlying conditions, but there isn't here. There's evidence that our guys came out every so often. There's no, plaintiff's counsel didn't even ask whether 185th would clear snow and ice on every occasion. It's just that they were expected to.
Did you put in an affidavit from your client that they didn't do anything on that day?
So my client doesn't remember. They produced a manager for 185th. 185th doesn't keep records because they're not legally obligated to do so. There's no duty to actually go out and clear the snow and ice. He could not remember. It was 2 years prior as to whether he was there when he went out and shoveled, if anybody even went out and shoveled in the first place. There are 3 other defendants here that should be held liable for this. There's the owner, of course, held liable under 7210 of the New York City Administrative Code. There's the other tenant that was contractually obligated to be held to go out and clear ice and snow. They never did so. There's also the city of New York that, of course, had a duty to fix their leaking fire hydrant. They were...
Is the only one here today opposing your motion, the plaintiff?
Correct, Your Honor. The city of New York did send out an employee to attempt to fix the fire hydrant sometime prior. Clearly, it didn't work. There was, the plaintiff took a video and took a picture of the icy conditions where she fell, right next to the fire hydrant, where the slope was coming down. This is 185th and I forget, Broadway, I think, where there is a slope coming down from where the fire hydrant is. The water from the fire hydrant directly leaked where she fell, and it was a cold day, of course.
So you're saying your client had nothing to do with whether or not there was ice formed by a leak from the hose?
Of course.
No duty towards it?
Of course, Your Honor. 185th doesn't have control of the fire hydrant. They couldn't touch that fire hydrant or be subject to fines. Same way as anybody else that would go out and they'd open up the fire hydrant on a hot day. You're gonna get fined. You're gonna get arrested most likely. You know, I kind of like the evidence that on prior occasions they would go out. I like that to almost like habit evidence for a medical malpractice case. They would go out and, employees of 185th will go out and shovel on certain occasions. Not all the time. There's no evidence that it would occur, that they would do this. But every snowstorm is different. Sometimes maybe it's just an inch and they would go out and they change it. There's no way that habit evidence of this would be admissible during a trial to prove that on this occasion, employees of 185th did go out and clear snow and ice.
Thank you.
Thank you.
Good afternoon, Your Honors. Robert Mena from Greenberg Law for the respondent plaintiff Yolanda Cruz. So the testimony collectively by the defendant's witnesses here in this case is that the garage, 185th Operating, took it upon itself to take control of the sidewalk area where my client slipped and fell. And
You use the word take control, but what evidence is in the record that other than that sometimes they went out and did do some snow removal? How does that, since they didn't have a duty to do so, how does that create a responsibility for them without any evidence that on this particular day they went out and did something which exacerbated the condition in some way?
Sure. It's the affirmative acts that were done by this party consistently over several months leading up to my client's
Can you tell
incident.
us where that is in the record? I don't recall that.
The affirmative acts? Well, the testimony is that the other tenant, Staples, that was the adjoining tenant of the building, testified, they had two witnesses, testified that the parking garage took it upon itself to clear that area on pretty much every occasion where there was snowfall.
At or around the time of this incident?
Yes, yes. And specifically, the question was January, February, and March.
What shows that their efforts enhance the risk?
Well, if you look at the pictures that were submitted, record 939, there are packets of snow around the area where my client fell, and
What connects the defendant to those snow piles?
Well, there's testimony record that this area was on a slope, and there could have been runoff, there could have been water runoff,
Counsel, you're saying
refreezing.
there could have been, that sounds like speculation.
Well-
Part of what's the problem here is that in a normal case, you have issues about constructive notice because you have a duty. And because you have a duty, you have to show affirmatively that you didn't, you didn't let go of that duty. But that's not true of this particular defendant. The defendant didn't have a duty. It wasn't the landowner. It wasn't the tenant obligated to lease to do it. So it didn't have any duty. So don't you have to come forward with some evidence as to this particular incident, that there's something they did that would impose liability on them?
Well, it's the defendant's motion here, so it would be our position that it's their burden to come forward with that proof that they
But
didn't.
didn't they come forward with
Not-
evidence that they don't have any duty and they didn't do anything that day
Well,
to exacerbate the condition?
In terms of the not doing anything, there was the testimony from the.
Well, even if they didn't the burden then switch to you to show that what they did, they say we shoveled and we shoveled, let's say we shoveled and we shoveled correctly. Isn't it then incumbent upon you to come forward with evidence showing that the way they shoveled or the way they salted enhanced the risk to a pedestrian?
Well, the testimony from the appellant's witness was that he doesn't remember what they did, if anything, around this time. So there was no testimony whether they cleared or didn't clear the area.
Also, what's 185th's duty or responsibility vis-a-vis the leaking fire hydrant?
Well, it's our position that they created a duty by their acts that went back several months in clearing the area.
So if one was to believe that they regularly shoveled the snow, they then imposed upon themselves a duty to fix a leaking fire hydrant that belongs to the city?
Well, not fix the leaking fire hydrant, but possibly clear the area of snow and ice around it, because they took it upon themselves to clear that area on a regular basis. The testimony from the other tenant, made it clear that, they assumed that the parking garage was going to do this on a regular basis. And again, in our position, it's our position that there's issues of fact here, whether or not, their acts or lack thereof, either created or enhanced the hazardous area where my client slipped and fell.
Thank you.
Okay, thank you.
Your Honors rightly look questionable when my adversary over here raised an idea of assumed duty. Nowhere in New York jurisprudence is there such thing as an assumed duty to clear snow and ice from pathways where you've maybe cleared it on prior occasions. There's 4 ways to be held liable in snow ice cases.
Well, and in this case, didn't Staples, the other tenant, have a contractual duty with regard to the snow and ice, which your client didn't have?
Correct, Your Honor. So there was contractual duty, there was a statutory duty by the owner, there was the common law duty by the city to clear the snow, the sidewalks. Of course, they delegate that duty through statute to the owner. And of course, there's the create and exacerbate prong of snow and ice cases. There's no such thing as an assumed duty to clear snow and ice. I don't think this is the case where we should be making new law, especially because there's 3 other defendants that can be held liable for plaintiff's injuries. Yeah, I could be wrong, it's not right, but there's also this runoff idea my adversary raised. There's no duty to direct runoff from melting snow or ice off of a specific location on someone's premise, especially because the sidewalks are not owned by a tenant, let alone an owner. They're owned by the city. If the city wants to come in and change the direction of runoff, they could have. They didn't. The runoff from the fire hydrant went to a certain location and it froze. The plaintiff fell. It has nothing to do with what a tenant did, especially because they were just being volunteers on prior occasions, some prior occasions. That's all I have. Thank you, Your Honors.
Thank you very much. Small versus the estate of Uri Landsman.
Good afternoon, Your Honors. My name is Melissa Geller. I represent the estate of Uri Landesman. Since my opponent is not here, I just wanted to highlight 2 points that are addressed to the reply. And that has to do, the first point has to do with competent evidence, because that's the standard at this stage under this sort of petition. And my opponent directs most of his reply to an analysis of the structure of Platinum Partners, which was a very large, very complicated hedge fund, as well as his analysis of certain financial records, very cursory financial records. And I just want to point out, to the extent it doesn't come through in the papers, Mr. Small is not a precipient witness. He doesn't have the foundation or the background to offer any of this analysis, and to the extent that he is, it is conjecture and speculation. The other point that I would like to emphasize to the court, and then I will be done, is that for all of the statements concerning Mr. Landesman's management role as it sets forth in the various corporate documents, Mr. Small came forward with nothing to show Mr. Landesman exercising any discretion, any control, or even any management function. In fact, most of the documentation shows Mr. Landesman deferring to Mr. Nordlich. And so at this stage of the case, as part of this petition, the petitioner does not come forward with any competent evidence demonstrating the kind of domination and control of a corporate entity that necessitates piercing the corporate veil. And that is all I have for the court today, unless the court has questions.
Thank you very much.
Thank you, Your Honors.
57th and 60th Street versus State Bank of Texas.
Good afternoon, Your Honor. Kenneth Kelly from Epstein, Becker, and Green, representing State Bank of Texas and two executives on the appeal. We ask that the judgment below be reversed and that the judgment be entered to dismiss the complaint and to remand the case back to the trial court for an assessment of attorney's fees. You've got a 1,800-page record before you. However, the facts that are decisive in this case are very few. The fact of the matter is,
There were payoff letters for both mortgages, is that so?
so yeah, the payoff letters were critical here. The payoff letters.
When were the payoff letters issued in the timeline which we're dealing with?
Well, their payoff letters were issued when the default first happened, which was in the early part of March. And then after that, the borrower, Mr. Liu and his two companies, started searching around to try and get more money to pay off. There was another set of payoff letters issued on July 24 and July 25, which was at the date of the second closing when everything was paid together. As I was going to say, those two payoff letters totaled $10 million, $10,244,000 and change. On the very day, July 25th, 2018, 3 wire transfers came in from the lawyers' respective escrow accounts exactly in that amount. Exactly in the amount that was shown on.
Let me focus in on a very specific issue, which I know was not raised till later on in the trial. But it's undisputed, assuming the language is unambiguous, that if the loans are repaid in full on or before the closing date, the defendant shall be entitled to retain all of such payment.
Right.
What about the specific argument made by opposing counsel that the loans were not repaid in full because the loans stated that the interest rate was 24% plus the amount of interest under the loan, and it's undisputed that all that was paid was 24% interest, therefore creating a situation where, even if we accept your argument that the loans are repaid in the way you're describing, they weren't repaid in full because the full interest required under the loan was not repaid in full.
That would be correct if you read if you didn't read the entire clause. The clause says that it's going to be 24% plus whatever the floating rate may happen to be on these two loans. Or another way of reading it is 24% of the floating rate plus whatever the loan rate is. But the fact is, the clause says it's going to be the 24% of the other, plus will otherwise be chargeable, or the maximum rate permitted by law, whichever is lower.
Right, but because it's a loan over a certain amount, there is no usury rate, so that is basically a nullity, isn't it?
No.
Because there is no usurious rate, so there's no highest rate allowed by law.
No, the contract says the highest rate allowed by law is 25%.
What? 25% according to what?
According to the penal law of New York.
But that doesn't apply to a loan of this size under New York.
But there's a difference between the maximum amount allowed by law and some other higher rate that a party could get into.
You're saying not the maximum, you're trying to argue that it's not the maximum allowed by law under any loan as opposed to this particular loan?
No, there's only one maximum law permitted by law, allowed by law, and that's 25%. There's other rates, 35%,
So that's your
30%.
argument, that the 25% rate should apply because that's the amount, that's the highest that in a loan, not such as a loan as this?
No, the argument is that it could be this floating rate or the maximum rate permitted by law, whichever is lower.
You didn't collect the maximum rate permitted by law either. You didn't collect 25%.
Yeah, but what the parties agreed to in their documentation, in the payoff letters, in the loans agreement here that's at issue, in the bills that were sent, and the amount that was paid off eventually by the borrower was 24%. That was what they agreed to.
Right, but
after the fact.
The language is that the loans are repaid in full. Why isn't their argument correct that the loans were not repaid in full because you did not collect the full amount of interest allowable under the agreement, under either interpretation that you're arguing.
Well, you have to look at the practical implications on this. The practical is the parties worked under the understanding that 24% was going to be the amount of the penalty rate. That's what was charged and that was paid. The plaintiff, a stranger to this deal, can't come in later on and say—
Where are you getting that from the language of the agreement? Because the language of the agreement says 24% over and above the rate of the agreement, or as you argue, the highest amount allowed by law, which is also not 24%. So where are you getting, even putting aside whatever their position, just from the unambiguous language of the agreement, where are you getting that it's 24%?
24% is what the parties acted under in their documentation.
And what happens if they were mistaken and that you really didn't get repaid in full?
Look, the bank thought that this is what was paid to them, that was due to them. That's what they had in their books and records, and that was they asked for from the borrower. The borrower paid exactly what was asked for him. And it's not up to a stranger to come in and say, oh, no, your agreement doesn't say that. Even the borrower agreed to it, the lender agreed to it, they paid it, they charged it.
Why can't they? You keep calling them a stranger, but why are they a stranger? You entered into a contract with them, and the contract that your client entered into them specifically references the standard if the loans are repaid in full. So by entering into that contract with them, didn't you then impose an obligation on your client to make sure that the loans are repaid in full?
The loan was repaid in full because what was charged by the bank to the borrower was paid by the borrower to the bank.
But the problem with that is that it's not up to the bank to decide on a different amount than what's in the contract because you included that term in your contract with the stranger to that contract.
No, what we included is it would be paid in full as the bank had it on his books, as the bank charged the plaintiff.
But why is the bank allowed to decide that as opposed to the contract deciding it? And the contract decides it as a different number.
Because it's the bank's contract with the borrower, not with them, that's determinative.
Okay, let's hear, I'm sorry, any more questions? Let's hear from opposing counsel, and you'll have a rebuttal.
Okay.
Good afternoon. May it please the Court. Jean Trevan Roy of Zeichner, Elman, and Krauss on behalf of Respondent, Plaintiff, 57th and 60th Street Lender.
So in everyday mortgage practice in this state, when a mortgage loan gets paid off, it gets paid off in response to a payoff letter. Isn't that correct? So what you had here is that 2 payoff letters were issued, and the borrower paid the amount called for by the payoff letter. Why doesn't that, at a minimum, if it's your position that they didn't pay in full, but first of all, why doesn't paying off those payoff letters constitute payment in full? And even if it doesn't it create at least an ambiguity if the borrowers pay the amount called for by the payoff letters, that should constitute payment in full, because that's the understanding that the borrower and creditor had in paying off this loan.
Yes, Judge, let me answer the two-part question in 2 parts. It is not payment in full just because the bank requested a specific amount in a payoff letter. The payoff letter indicates, and by the way, the payoff letter here, the payoff letters for the pair of loans were issued after the loan sale agreement. I believe my colleague, Mr.
But before this litigation?
Before the litigation, yes, absolutely. But what was done at the time of default were demands, and in one case a foreclosure action, not payoff letters, just for clarity. But the payoff letter binds the bank, typically, to accept the amount tendered, if it's the full amount in the payoff letter, in exchange for a satisfaction or an assignment if the borrower has assignment rights. The payoff letter does not necessarily reflect the full amount due under the loan documents. Lenders, such as State Bank, are at liberty to reduce amounts due, to waive fees, to waive penalties, to waive interest, and issue payoff letters in any amount they choose.
And where does that fit into this? Don't the circumstances here show that at worst, the lender made a mistake as to what they should have been? They took an amount, which on the surface seems like, well, the rate's 24% if you're in default. They took an amount which on the surface seemed to be the amount that's due. And now as we look at it, we see, well, actually, there was a greater amount that they could have or should have asked for. So it looks like a good faith mistake.
We do not contend, nor did we attempt to demonstrate that this was an intentional engineering of an amount in a payoff statement that was less than the amount due under the loan documents. If it was less than in full, then there was a breach. There was a breach whether the breach was intentional or not, with respect to in full. In any event, there was no repayment of the loan. There was consideration paid to the bank in exchange for 2 assignments. That consideration was about $2 million greater than the bank would have been bound to accept from my client in exchange for the identical 2 assignments. So there was a breach of the loan being repaid provision. There was a breach of the provision that required that that repayment be in full. And there was a breach of the confidentiality agreement, which was used, that breach was used to implement the scheme to assign these loans to 2 other purchasers for a couple of $1 million more than the bank had agreed to accept from my client. And one of those purchasers, or assignees, was TIC Capital, a small entity owned by the father of the bank's president. That scheme could only have been effectuated if there had been a breach of the confidentiality provision. So those claims are not duplicative. The damages are duplicative, and the compensatory damages here are such on the 3 breaches that the trial court did not need to award separate damages on the breach of the covenant of good faith and fair dealing, but it is a separate claim. And again, back to Your Honor's question, the lower court, I think, said succinctly and accurately that the question of whether the bank subjectively considered itself repaid in full is not dispositive of the question of whether it was, in fact, repaid and repaid in full. These loans were assigned to the 2 assignees that got them instead of my client at their full multi-million-dollar balances each. There was not a penny of the wire transfers that Mr. Kelly outlines that went to reduce the loan balances.
Are there any more questions from the bench?
Yes, Judge.
As I understand what your argument is, that you're saying that defendant's result could only be reached if the loan sale agreement had said that it could be terminated either if the bank was paid in full or if the bank was satisfied with what it had been paid. But since that second clause wasn't there, that's not good enough.
In essence, yes.
Thank you.
Thank you.
Let me call your attention to cases that we cited in our brief, referring to the doctrine of practical construction, where parties to a contract guided by self-interest enforce it for a long time by a consistent and a uniform course of conduct so as to give it a practical meaning. The courts will treat it as having that meaning.
Counsel, doesn't the doctrine of practical construction only apply in instances where the language is ambiguous as opposed to unambiguous?
I think it could be ambiguous here because it's either 24% of 8% or 24% plus 8%.
So, but for us to accept your argument about practical construction, we would have to find that it's ambiguous.
I think that's right. I think also you have to show that the parties acted. You asked what was the date of the payoff letter. It was the first one is at March 7th, and the other one was the same date. This is at page 1411 of the transcript of the record. And let me just ask one other thing. The fact is that whether a loan is paid Here on one day, the bank said, you owe me $10,244,000. On the next day, the bank received $10,244,000. The question is whether a payment in full is ambiguous, is not ambiguous. There's no need to do that.
But the
If I
fact
cite
that the
to,
bank was satisfied with what it received is not the same as saying that the bank received everything it was entitled to.
no, what the bank,
And
no,
paid in
what's-
full would require that it receive everything to which it was entitled.
what the bank had on its books and records was that it was owed this much money, and it got paid that much money. It was a mistake of 1%, which is de minimis. It's the bank's fault. Shame on them for not charging 25% instead of 24%. But the fact of the matter is, that's what they did, that's what they were expecting, and that's what they received.
But there's nothing like, okay.
Okay, and just,
Thank you very much, counsel. Thank you. The next case is People versus Pettiford.
Good afternoon, Your Honors, and may it please the Court. I'm Liza Batkin from the Legal Aid Society representing Errol Pettiford. This Court should reduce Mr. Pettiford's sentence because he has an extremely minimal criminal history and an outstanding record of employment. He's already served the minimum term of probation, and requiring him to serve the rest of that term will only hamper his ability to keep contributing meaningfully to society.
Counsel, how do you get around the waiver of right to appeal?
The appeal waiver doesn't bar this court's review because it wasn't knowing and voluntary. There were multiple problems with the waiver, chief among them the colloquy and written waiver both inaccurately implied that Mr. Pettiford would be waiving the right to appellate counsel and
How do you say that he was waiving the right to appellate counsel? What he was told by the judge was that means is that you could ask an appellate court to review the judgment of conviction on an appeal through your lawyer.
That's right. I think you're quoting language from the colloquy when that's how the court is defining what the right to appeal is. And then the court goes on to say that he would be waiving the right to bring most claims under that right to appeal, sort of broadly defined. And when it goes on to say that there were a few claims he could bring, it never specified that he would have the right to appellate counsel or poor person relief in bringing those claims. And I think
Has the Court of Appeals ever ruled that what you're suggesting that the court didn't advise has to be advised?
in the Court of Appeals in People versus Busono did invalidate an appeal waiver from People versus Daniels based on what Judge Garcia in dissent described as a single mischaracterization of the appeal right, which was, and I quote, the implication in the oral colloquy that defendant was losing the attendant right to appellate counsel. So the same mischaracterization that took place.
Again, in the written appeal, it says, I understand that the right to appeal would have allowed me with the assistance of an attorney.
That's right. So I think if we look at the language, I understand that the right to appeal would have allowed me, with the assistance of an attorney, to have a higher court review my conviction. It then goes on to say, I am waiving that right to appeal as a condition of this plea. So Mr. Pettiford's understanding was that he was waiving that right to appeal, so defined, to include the assistance of an attorney. Therefore, it suggests that he would have been waiving the right to that assistance.
So you're reading that whole sentence as referring that the waiver is going on the right to counsel.
I'm reading it as, I'm reading the waiver as defining the right to appeal as including the assistance of an attorney, and then saying that Mr. Pettiford was waiving that right to appeal.
I understand that the right to appeal would have allowed me with the assistance of an attorney to have a higher court review my conviction and sentence, particularly the excessiveness of my sentence and the resolution of any suppression motion that I may have made. I am waiving that right to appeal as a condition of this plea.
That's right. That's right. So he's
And
saying
you're interpreting that to me that is waiving his right to have an attorney.
That's right. That's right, Your Honor. And if I may, I'd like to turn to the equities in this case, which are incredibly strong. Mr. Pettiford is a remarkable...
Well, the fact that he got probation on a loaded firearm in New York City, I think that's remarkable.
The fact that the lower court took into account his remarkable history and the particular nature of this crime and reached a sentence of the maximum term of probation doesn't prevent this court from
Isn't
reaching.
incarceration mandatory on this sort of a plea? How did Supreme Court get around the incarceration requirement on this sort of weapons plea?
Penal Law 65 does allow courts to sentence a person to probation upon conviction of any crime, with few exceptions that don't include this crime, if the court believes that institutional confinement isn't necessary. And the trial court did put reasons on the record, which included his remarkable history. He's remarkably hardworking. He has held a job since he was 18 years
Also,
old.
you keep saying remarkable history. For me, remarkable history is someone that's never been arrested, never been convicted. And I'm not saying he has a terrible history, but let's not call it remarkable. I mean, he does have 2 misdemeanor convictions, right?
He has 2 misdemeanor convictions from Virginia arising out of a false identification to law enforcement, but he lived in New York for the first 24 years of his life.
Doesn't that actually, it seems to me that if he's so remarkable and lived in New York for 24 years of his life, then he should have been able to think ahead to the fact that this gun, which was registered in Virginia, would not be legal in New York. And that seems to me decidedly unremarkable that he didn't think about that. And contrary to our state's policies of wanting to regulate the presence of guns very carefully. So I don't understand why that doesn't count against, his remarkableness almost counts against you, because he should have thought ahead about that.
May I respond, Your Honor? Mr. Pettiford has taken full responsibility for that regrettable one-time mistake, and he submitted to the punishment given to him, which was the maximum term of probation. But for the reasons discussed here and in our briefs, we ask this court to resentence him to the minimum term of probation of 3 years or conditional discharge.
Thank you.
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the Office of the District Attorney, Bronx County. As Your Honors pointed out, with respect to the waiver, our interpretation is that the oral colloquy is being given a very parse reading, insofar as that the trial court judge made it very clear that the defendant could file a notice of appeal, and that this was an independent, distinct, and separate right away from the trial rights that he would waive as a result of him taking this plea. And I believe that by my friend's presence here today, that the claim that he was not advised that he couldn't have appellate counsel and was waiving that array seems to be demonstrably meritless on its face. Your Honor pointed out that with respect to the firearm charge, the facts of this are important. The defendant wasn't found inside his home or place of business with a loaded firearm he had no lawful license to have. Instead, he was found outside with the gun in his waistband, and it was observed by the officers of him having this gun in his waistband at the time of his arrest.
Counsel, what happened here was as a result of a plea bargain that your office, I don't know if initiated, but absolutely consented to, correct?
That is correct, Your Honor.
Also, it was your office, I think, that agreed with whatever the special findings were of the lower court that prevented an incarceratory sentence.
That is correct, and we took into consideration the fact that the defendant had steady employment in his new domicile of Virginia.
Your office went to extraordinary efforts to avoid an incarceratory sentence here.
We did, and we did exercise our certain discretion under Penal Law 65 to deviate away from the mandatory sentence that he would have faced otherwise. Your Honor, as your Honors will look at our brief, he faced a maximum of 15 years on the top count of the criminal complaint.
Counsel, what were those special findings that would allow the court to deviate from the incarceratory sentence? Because what I have here is he lived in Virginia, had a full-time job, and had no criminal record in New York. Is that it?
Yep, that was it, and based on the negotiations that occurred between counsel and the people, that there was an agreement that the court subscribed to and submitted to by Superior Court information that the court would deviate away from the mandatory minimum that you would have taken on the plea.
Is it your position on this appeal that those factors are enough to deviate from the incarceratory sentence?
I believe that with respect to every case is individualized. I think that at the time that people made an individualized determination with this particular defendant, that given his lack...
Anyhow, no one's challenging that aspect of things, so...
Well, I believe that what's being...
I think you made some mention of it in your brief, however.
I think that one may end up saying that it's a little bit a lot more outside the realms of potential legality, but in any event, there is a possibility that
I know that the defendant points to Bruin as calling for a change in outlook on this, but there's no view that Bruin allows someone to go around with a loaded weapon, with an unlicensed loaded weapon in New York.
That is correct, Your Honor.
Even under Bruin.
Bruin only stands for the presumption that the proper cause requirement under Penal Law 400 at the time was unconstitutional. It did not vacate the entirety of the statute regarding gun licensing. It has since been amended to address that issue. And I would also like to note that with respect to out-of-state licenses, the Attorney General's office back in 1997 pointed out that under very, very, very limited circumstances does the state of New York honor out-of-state gun permits, and none of those considerations and none of those exceptions applied in this defendant's case, nor did the defendant make that claim at all. And I believe that that claiming Bruin can suggest that the defendant somehow should have a lower probationary sentence, which is already lenient enough given the totality of the circumstances, is unfounded. And for that reason, Your Honor, I ask that you affirm.
Thank you.
I'd just like to make 2 points on rebuttal. The first is that in making the record for the probationary sentence, the trial court specifically, yes, referred to his work record, but specifically referred to the fact that he had moved to Virginia with his cousin and ended up homeless for a period of several months, and then worked his way out of homelessness while sleeping in a laundromat and working 2 jobs. The other point I want to make is with regard to Bruin. We're not raising Bruin to argue that his conviction was unconstitutional. He has submitted to the punishment that he received, but we do think it's relevant to the court's consideration of what counts as a fair sentence, that the Supreme Court, since his crime, has recognized that carrying a gun in public for self-defense purposes deserves broad constitutional solicitude.
You still need a license, right? At least in New York.
Yes, Your Honor, yes. He violated a crime in New York that he took full responsibility for, and all we're asking is that this court reduce his probationary sentence by 2 years.
Thank you.
Isn't that part of taking responsibility? Serving your
Iberdrola Energy versus MUFG Union Bank.
How many of those boxes?
Good afternoon, Your Honors. Rory Schneider on behalf of defendants, appellants, whom I'll refer to for simplicity's sake as the lenders. Everyone involved here, Oaktree, Footprint, Iberdrola, and the lenders, all lost significant sums, hundreds of millions of dollars, in connection with the construction of this power plant. Iberdrola's claims against the lenders are simply an attempt to reallocate those losses in a way that's directly contrary to the governing agreements and the capital structure of the project.
Why don't they have a viable argument that it was an improper drawdown on the letter of credit, and since it was your client who got the proceeds of the letter of credit, that they have a greater right to those proceeds than your client does, and your client acted tortiously in preventing them from receiving those proceeds, which the arbitrator clearly said they were entitled to?
Well, Your Honor, there was nothing improper about the draw. The draw was expressly and unanimously approved by the duly constituted arbitration panel.
The arbitration panel didn't make a ruling on the merits when they said that the drawdown could occur. They didn't say that it was proper under the circumstances of the case in the project for that money to be drawn down. They just said that it could be drawn down based on the procedural requirements as to how letters of credit work.
Right. The letter of credit is a separate independent contract.
That's a different issue than after the arbitration panel ruled that the letter of credit proceeds should go to the plaintiff. The bank then obtain those funds?
What the arbitral panel went on to find in its final award, that the termination of the underlying EPC contract was unjustified. It did not find, and it expressly declined to revisit the determination that the draw on the letter of credit was proper under the terms of that independent letter of credit.
Didn't it find that plaintiff was entitled to the return of the entire amount of the letter of credit proceeds at the end in its arbitration award?
It included in its arbitration award $140 million to account for the letter of credit draw, but that was a claim in
Therefore, finding that they were entitled to the return of the proceeds of the letter of credit. They made an express finding that it was plaintiff who was entitled to it rather than the lenders.
Yes, but that did not have to do with the draw proceeds specifically. It was undisputed that eventually...
I'm sorry, you're making a distinction in the actual drawdown versus who gets the proceeds of the drawdown?
No, what I'm saying is that upon the draw, the proceeds became validly Footprint's property. And in fact, the panel expressly and unanimously found that there was a real prospect that even if Iberdrola won a final award, that award would be uncollectible.
Who had the proceeds of the letter of credit at the time of the arbitration award, where the arbitrator made the finding that the proceeds should go to plaintiff? Who retained control at that moment?
At that point, the majority of it was still with Footprint, in an account over which the lenders had a lien.
Why do they not have a viable claim by the fact that those proceeds, which they specifically found plaintiff had a right to, ended up in the hands of the lender after they made that finding? Why doesn't that state a viable claim on the part of the lenders for aiding and abetting a tortious interference with contract?
Well, let's be clear, the tortious interference claim, the aiding and abetting claim, has to do with the allegation that by consenting to the EPC contract's termination, the lender somehow aided and abetted Oaktree's tortious interference. It doesn't have to do with the proceeds of the draw specifically. But in relation to Your Honor's question, upon the draw being approved, those proceeds became validly Footprint's property, and upon doing so, that subjected...
Counsel, what if the draw exceeded the amount necessary to make Footprint whole? In other words, that's an allegation in the complaint, is it not?
It is an allegation in the complaint, but the EPC contract places no limits on the draw, and in fact, the panel expressly approved a draw to the full amount.
But it did that, and as Justice Kern pointed out, the panel said nothing about post-draw remedies.
Well, it did. It addressed the post-draw remedies by understanding that once those proceeds were drawn upon, and properly so, pursuant to the letter of credit, that they could be used and they would be subject to the lender's lien. The Iberdrola made a second attempt to put restrictions around what Footprint can do with the draw proceeds. And when it did so, it was explicitly in reference to the lender's lien. Iberdrola understood that if the panel didn't act, those proceeds would be subject to a priority lien, and there would be a real risk that the panel found Iberdrola ran and didn't account for when it accepted this project. And so
let me interrupt and just go to a separate question for a second. Why hasn't any party, and I understand that everyone gets to chart their own course of litigation, but why has nobody requested a consolidation of this appeal with the appeal having to do with the actual tortious interference claim? Wouldn't it make some sense for those claims to all be heard together in this court by the same panel?
I think there is sense in thinking about that, Your Honor, but our view is that the tortious interference claim against the lenders, the idea that they aided and abetted, it has nothing to do with the result of the underlying fraud claim against Oaktree.
To determine an aiding and abetting a tortious interference claim or a conspiracy to commit a tortious interference claim, don't you necessarily have to look into whether it's a viable tortious interference claim, which is explicitly the subject of the other appeal, which we do not have before us today and is going to come theoretically in September?
So to be clear, yes, you do need to evaluate whether there's a viable tortious interference claim.
Why has no one asked for those cases to be consolidated, or those appeals to be consolidated?
As I understand it, the appeal has to do with a fraud claim against Oaktree, and the record is already clear in this case that the underlying tortious interference alleged against Oaktree is not a viable one. And that's because there's no dispute that as Footprint's parent company, Oaktree is entitled to interfere with the contracts of its subsidiary unless it engages in fraudulent or illegal conduct. And respectfully,
that's not part of the appeal that's coming in September? Doesn't have anything to do with the tortious interference claim?
It has to do with whether they can allege fraud, to be sure, but Honestly, Your Honor, the arbitral panel already found that it can't make that showing. It found that Oak Tree
What,
and
if
Footprint.
anything, did the arbitration panel find as to Oak Tree's conduct?
So Oak Tree is Footprint's parent, and even Iberdrola in its complaint and its briefing aligned the two, and even alleges that there was a conspiracy between them to interfere. That Plan B, the conduct leading up to the decision to terminate the EPC contract, was expressly before. It was the majority of what the arbitral panel was asked to consider. And when the arbitral panel considered it and considered whether it constituted deceptive practices, it found that it did not. It didn't condone the practices. It said they were sharp business practices, but it said that it was all motivated to protect Footprint's commercial position.
Both sides engaged in sharp practices, right?
They didn't engage in any determination there, though, whether there was any tortious interference with the contract, and they didn't engage in any ruling whatsoever about Oak Tree's behavior, because Oak Tree wasn't before it as a party.
Respectfully, it was all the same conduct. And if you actually look at the briefing,
But Oak Tree, as you've articulated, Oak Tree and Footprint are not the same. One's the parent and one's the actual entity entering into the contract. So making any kind of finding about what Footprint did or did not do would not be dispositive as to what Oak Tree did or did not do.
respectfully, Your Honor, that's not the case. It's all exactly the same conduct, and Iberdrola expressly emphasizes the fact that most of the officers and directors of Footprint were Oak Tree employees, and that this was a scheme designed by both of them, and the arbitrators went on to find that that conduct here alleged against Oak Tree, and in the arbitration alleged against Footprint, was not deceptive, and it was done to protect Footprint's commercial position in the project. And under
Let's hear from opposing counsel. You have a rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honor, Your Honors. Robert Mockler of Septo & Johnson, representing Iberdrola Energy Projects, as stated in the briefs, would request permission from my colleague Thomas Watson to appear here.
Permission is granted.
Thank you.
Good afternoon. My name is Thomas Watson on behalf of Iberdrola Energy Projects, or IEP. To respond to some of the points, first of all, as for issue preclusion in the arbitration, that may be something that comes down the road. We're here on a motion to dismiss, something to be cited at a later basis, a later date. There was no discovery and no claims asserted against the lenders or Oak Tree in the arbitration.
Counsel, I have some questions about the unjust enrichment claim. What remedy would your client receive from the unjust enrichment claim that it wouldn't also receive if it succeeded on the claims for aiding and abetting or conspiracy with regard to the tortious interference?
I don't think there is necessarily a different ultimate financial outcome, but certainly unjust enrichment would include disgorgement of the $85 million that was taken while the award was pending. And to the other justice's comment, that the contract in section 14.3 says it's a performance letter of credit. $85 million was not needed for performance and was drawn based on...
That's also a breach of contract, though.
It is. We believe this case should be decided under Massachusetts law, and so the breach of contract claim, if it existed, and under New York law, there's no adequate remedy here because there can't be a breach of contract claim for that. But the unjust enrichment was the inequitable taking of those funds based on a false certification that the lenders knew, and then they swept that money after the award had indicated that the money should be repaid.
What about the cases which say you don't have an unjust enrichment claim when the subject of that claim is also the subject of an actual contract?
There is case law to that effect, but what's missing, and if you look at I believe it's the Sternberg case, in Allenby, it's only when the contract explicitly covers the issue. And in this case, the contract does not specifically cover what happens where the lenders take the remaining amount from the letter of credit from the debtor before an award can be paid. So it's not addressed there. And then again, if you look at the Menino,
You would acknowledge that the contract addresses what steps can be taken with regard to the letter of credit, but that this particular tortious behavior towards the proceeds of the letter of credit is not governed by contract. Is that essentially what you're saying?
Correct, yes. And also the contract doesn't address these issues. There's a case, Atria, that's cited really only on reply, where on the conversion claim where, and that's well distinguished by North American Airlines. But in that case, the contract has very specific language, says if there's an improper draw.
We found in that case, not in Atria, but in North American, that there is a viable conversion claim, even though there's a letter of credit contract, but that doesn't really address the unjust enrichment issue, which is different than the conversion claim.
Yes, Your Honor. And I believe, again, Menino talks about unjust enrichment, and where there's no adequate remedy at law, unjust enrichment's appropriate. And if you go back, just black letter law, the restatement talks about money procured through false or fraudulent means, an unjust enrichment claim is stated, and that's what we have alleged here.
Why was it false or fraudulent? It might have been violative of contract or enforcement, but why is it, what's the fraud claim in this case?
We have alleged that as part of what they termed Plan B, they made multiple misrepresentations to Iberdrola to cause it to forbear its remedies, to incur additional expenses, to wait until the very last moment to terminate the contract based on pretext and based on a false certification for the letter of credit. And the letter of credit was drawn, but the letter of credit draw, and I direct your attention to R782 in the record.
Are there any conditions in the letter? I mean, that was part of the mystery of this case. Sure. Are there any conditions in the letter of credit to when it can be drawn?
Yes, it requires a material default certified by the lenders, and we fought the draw, and there was an arbitral, an interim decision, but that decision explicitly said, and this is a very key point, it is without prejudice to the ultimate deliberations. The ultimate deliberations found the letter of credit draw was improper, and that's at R782 in the pleadings.
But as to the unjust enrichment, you're in fact expressly relying on the EPC contract and pleading the unjust enrichment cause of action.
I don't believe so. I think we're simply saying money was taken from the letter of credit, were properly subrogated to it.
By improperly terminating the EPC contract, the lenders received a windfall in the form of the letter of credit proceeds. You're specifically pointing to the contract.
They're pointing to, there's actually not really any specific term in the contract that allocates money to the lenders. Number one, they do get a security interest that Footprint can give to it. So Footprint can only give a security interest in that which Footprint has a legal right to. Any right that it obtained at all when the letter of credit was drawn was conditional and expressly conditioned by the arbitrators on the ultimate deliberations in the award. So Footprint, to the extent it may have been able to give the lenders a security interest, certainly by the time of the award, it could not. And again, it's a performance letter of credit. So there's $85 million that wasn't spent.
Look at, I'm going to go back to something you said earlier, because the letter of credit itself doesn't have that term or condition, which is why they could draw on it. The letter of credit doesn't say you have to have a material breach to draw. It doesn't have any conditions in the letter of credit.
The certification for the letter of credit does require that.
But if you're claiming that they withdrew it in violation of the certification, then doesn't that bring you back to the contract?
It brings us here to fraud, because it was part of a conspiracy to tortiously interfere with the contract, yes.
But you're saying essentially that they violated the contract, so why isn't that governed by contract and therefore gives you no basis for an unjust enrichment claim under our precedent?
Well, we're saying they tortiously interfered with the contract. And again, if you look at the cases on unjust enrichment, Sebastian Holdings is another one. It doesn't preclude unjust enrichment claims that arise not from express terms in the contract. And for example, I believe it's in Sebastian, a party that sells an apartment building acts as a broker where the contract doesn't specify the amount of the commission, the party can sue for unjust enrichment. Here we have a party that we're not even a counterparty with, taking funds extra contractually, and the contract doesn't address in any specific way what happens, and therefore unjust enrichment is proper. You can imagine sophisticated banks saying, maybe they will after this case, where there's an unlawful draw, your remedy is limited to X. There's no such limits in this contract. And that's why we believe.
Counsel, what about the omnibus agreement? Does that give you further evidence of fraud?
I'm sorry, Ms.
The amended credit agreement, also known as the omnibus agreement.
Yes.
How do you use that to show fraud?
Sure. It demonstrates, for example, the draw. May I
Let me finish the question.
Under the amendments, a default from the award became immediately an event of default that allowed the lenders to draw the money as quickly as they did out of footprint, the $85 million that remained from the letter of credit. Had it not been for those amendments, the time to complete payment under the award would have passed, which was 30 days, before they could have done that draw. So it was all part of a scheme to make it harder for footprint to act independently, to settle with the Iberdrola, to pay it by paying an award.
Thank you. You have time for rebuttal, too.
Thank you, Your Honors. 2 brief points on rebuttal. 1, unjust enrichment claims, equitable claims, are not permitted where the subject matter of those claims are addressed by comprehensive and valid agreements. That is absolutely the case in this case. The subject matter of this case has to do with...
But no one contemplated in this contract that a non-party would take the proceeds of the letter of credit. So how is that governed by the contract?
That's not the case, Your Honor. The letter of credit was expressly assigned to the lenders as part of the collateral for this loan. And so it was expressly understood that if there was a draw in the event of a dispute between Iberdrola and Footprint, that the Footprint would be entitled to draw on those proceeds and that they would be put into an account over which the lenders had a first
Right, and there was no
priority.
limitation on the assignment of the letter of credit.
Excuse me, Your Honor?
The letter of credit did not itself contain any prohibition on such an assignment.
That's absolutely right.
And there can be no surprise that if things went south, that the letter of credit proceeds ends up with lenders.
Precisely. This all played out exactly as the court contemplated in its prior precedent in Vertigo, Belgium, which I direct Your Honor's attention to. In that case, it was expressly recognized the claim was a conversion claim based on a supposed misrepresentation in documents submitted in support of a draw on a letter of credit. And what this court said was, as the applicant of the letter of credit, you're not a party, you have limited rights, and if you exercise those rights and you don't prevent the draw, your rights reside in the underlying contract.
Thank you.
Thank you, Your Honor.
You have a minute.
One brief point in response, and it's in the record at R661 is the actual letter of credit and the language, and it requires a certification that IEP has breached or failed to perform when and as required one or more of its material obligations. We've alleged that the lenders who executed a document to approve this termination and approve the draw of the letter of credit knew that the certification was being done falsely. And that's what leads to the unjust enrichment claim, and it leads to also the tortious interference.
Isn't that, but if, isn't, well, as you just said, that action also leads to the tortious interference claim. So why isn't that, what does the unjust enrichment claim do for you that is not accomplished by the tortious interference claim?
As I said, I think it's simply a different legal avenue to relief.
Counsel, what if we affirm the Oak Tree action? Does that fatally undermine either the conspiracy or the aiding and abetting tortious interference?
It does not. There's case law to the point that may I finish?
You can answer the question.
Yeah, there's case law that where an underlying co-conspirator has exculpation, that you may proceed with the case against the other parties.
Right. Well, the trial court went off on the non-recourse provision, correct?
Correct.
So what if we, just hypothetically, what if we were to go off on another provision or find some other way to find in favor of Oak Tree? I guess this is very hypothetical, and I'm sorry to put you to such a
Sure. I think there's really clear wrongful conduct here, and so it would be very surprising if you would find that, and I expect that you will reverse on the Oak Tree appeal as well. But they are independent, which is why we didn't move to consolidate. Perhaps we should have. It's obviously a suggestion that I take seriously. It is the case, though, that the conspiracy claims and aiding and abetting claims stand on their own. You're entitled to pursue any party who's a participant in a conspiracy, and that's what we've done.
Thank you very much.
Thank you.
The next and last case is Hammond versus Equinox Holdings.
Good afternoon, Your Honors. May it please the Court. My name is Ori Nazarian. I represent the defendant, appellant, respondent, Michael Alexander. This Court can decide this appeal and dismiss what remains of Stephen Hammond's case by simply looking at the complaint. The complaint was not inartfully pled. It was very artful. It was very strategic. But those choices preclude any relief against Alexander. So as a threshold matter, the underlying order dismissed all remaining claims against Alexander except for the defamation claim premised on paragraphs 28 and 29 of the complaint. Paragraph 28 alleges that Alexander witnessed a member masturbating in a steam room. That's it. There's no target, there's no name. And it's made upon information and belief. And it's made from one Equinox employee to another Equinox employee. Paragraph 29.
But we clearly know from reading the complaint exactly who the players are. There's no ambiguity or question, especially with respect to the Equinox employees in those conversations, exactly who was being referred to in all of these conversations.
And that might be true down the line when you
And
look
when you
at...
get to paragraph 29, it names Steve Hammond. So when you move from one to the, from the defendant to Sanders to, it becomes clear that what you're talking about is Hammond.
If we're doing a fact-finding mission based even on the allegations in the complaint...
Well, that's not a fact-finding mission. That's just moving from point 1 to point 2 is set forth between paragraphs 28 and 29.
And respectfully, again, if we're trying to identify who the person is, then yes, you can read the two together and identify that by implication, it was Hammond in the steam room. However, for purposes of defamation, Alexander never identified Hammond as the person he saw. That identification was made separately by Terrence Sander, also an Equinox employee, and even that allegation is also upon information and belief.
There's no ambiguity here, though, that he identified him and he is the person, he is one who all these actions have since occurred as a result of. That's not an ambiguity in this case.
No, I agree. It's not an ambiguity in identifying who it was, but in the actual...
Or who he accused. I mean, there's no question for anybody at this point that in the complaint, that is exactly what he is alleging, that he was accused by this employee, by this defendant.
Well, but the statement, the very statement that Alexander made, which was that he witnessed somebody masturbating in a steam room...
To the end of paragraph 29, I'd asked, quote, FDA Michael Alexander to wait at the front desk to identify the member, and then when you have Sander identifying the member, so it becomes clear that this identification is coming from Alexander.
And respectfully, I disagree because, again, it's the making of the statement, which is very specific to a defamation claim, that is the issue. And here, Alexander wasn't trying to identify any specific person. He simply stated that he witnessed a member masturbating in the steam room. And he made this within the common interest exception.
Let's go on to that. Why don't we talk about the common interest privilege and whether or not malice was sufficiently alleged in this case?
Yeah, so, and just to touch on the common interest exception or the privilege, this is made from one Equinox employee to another, even within the allegations in the complaint, including paragraph 113, Alexander is explicitly pled as an Equinox employee. They even brought up the fact that this was made on an Equinox employee.
Let's assume that the privilege applies. What's your response to the argument that there was malice in the statement, and therefore it overcomes the privilege?
Okay, yeah, so there are two responses, and the first is that the one paragraph supposedly addressing the issue of malice is paragraph 45, at least as determined by the lower court, and that too is upon information and belief, and it's conclusory. It just simply says, upon information and belief, this was made intentionally.
If what Alexander did was a blatant lie, it's established, we've got a pleading motion here. This is not summary judgment. We're talking about what we're going to do on a pleading motion. If it's established that what Alexander did was a blatant lie, that wouldn't establish malice?
Respectfully,
or at least
no.
create an issue of fact whether there was malice?
At least on what we have in front of us, no. And the reason is because even by this court's decision in Carrega.
Well, as a matter of pleading, the claim is made that it was a blatant lie, is it not?
Well, that's both conclusory and it's the ultimate conclusion. I mean, we could just say in a pleading, he committed X, Y, Z.
Well, there are only two people. There are only two people to this incident. One says it happened and one says it didn't happen. So on a pleading motion, do we dismiss the complaint, basically, notwithstanding the assertion by the plaintiff that this never happened?
There has to be
Which, if it never happened, would establish malice, would it not?
Well, to address your first question, based on what is in the complaint, it has to be dismissed because the claim of malice is conclusory. It's not based on anything at all. Again, if down the line a fact finder concludes that this was a lie, it would change the calculation, but that's not what...
Why, if it's a blatant lie, doesn't it establish malice? Or at least create an issue of fact as to malice?
That would be a question that might come up if the complaint survived.
But how would it survive if we accept your argument that it should be dismissed because there's not a sufficient allegation of malice? How would any court ever get to make a determination that you're saying would be made later in the case?
Sure, and
we'd be done with it, so there would never be another chance to prove that it was a lie.
But there would have to be something beyond just saying that this was made with malice and making it upon...
What would be the something in a circumstance such as this case? What else could there be?
Under such circumstances, I don't know. Here, the whole issue is that it is based on nothing. And even that nothing is based on information and belief. So by this court's previous decision on the appeal with the Equinox motion to dismiss, this court concluded that Hammond did not discharge his ability to show malice based on the same complaint.
Thank you.
Okay, thank you.
Good afternoon, Your Honors. Ethan Leonard, the law office Neil Brickman for Mr. Hammond. Justice Friedman, you hit it directly on the head. Malice is proven under Lieberman from the Court of Appeals or from this court under Diorio that malice defeats the privilege, and malice can be shown either by spite or ill will or by knowledge of falsity of the truth of the statement or even reckless disregard for the truth. So the complaint alleges, and maybe it was overdone, but probably no fewer than 40 times that this was a false allegation. And the false allegation was that Mr. Hammond was masturbating in the steam room. That in itself constitutes malice as a matter of law, the false statement, and nothing really needs to be further on that point. With regard to the dismissal of the claims for against either the statements to the police or the statements to the press, what was disregarded is the fact that not only the specific allegations in the complaint, and I'm happy to go through those that will suffice, but also that it was referred to throughout the complaint as the false statement.
Counsel, when you go to the actual allegations in the complaint, which refer to the statements to the police and the statements to the press, they're very, very, very vague, and they really don't say what the brief is arguing they say. They may say, go look at other parts of the complaint, but the part where it says this is a defamation, and you look at it, it's on its face, it does not appear to be enough, which I think is what the court below held, that this isn't enough to state a valid claim for defamation.
Your Honor, if I might, can I take those two parts separately, vis-a-vis the press and the police? Vis-a-vis the press, it's very clear that what was said is the false allegation, meaning that this was a term, frankly, a term of art that's used throughout the complaint. Courts have routinely held that you have to read the entirety of the complaint together as one.
But defamation is different.
No, but even...
Normally, you do read the entire complaint to see whether or not a claim is made. But in defamation, there's very clear particularity requirements that you have to say with particularity, this was the exact defamatory language used in this particular circumstance. And that I'm not sure we've seen in the complaint, which I think is what the lower court said. So maybe you can show me where in the complaint, when it refers to the actual defamation, let's say the police, what they're actually claiming the defendant said to the police that's defamatory.
Yes, Your Honor. But if I might take a step back, what the Court of Appeals said in November v. Time was that challenge statements are not to be read in isolation. This is with regard to a defamation case, but must be pursued as the average reader would against the whole scope and intent. The statements must not be interpreted in their mildest and most offensive form so as to hold them non-libelous.
That's usually in terms of deciding whether it's an opinion or a fact, not really so much in terms of whether there's defamation in the first instance. You have to look at what's being alleged.
Yes, Your Honor. And so, again, the false statement that he was masturbating in the steam room was specifically, if you look at...
Do you allege he made that statement to the reporter?
Yes, because, first of all,
Where do you allege that?
in paragraph 68, record 35, Alexander was quoted anonymously in New York Post article concerning the false allegation, meaning the masturbation in the steam room. And he was encouraged not to file a report on the same. In paragraph...
where does it just... doesn't say that.
Complaint, it says, was quoted anonymously in the New York Post article concerning his May 21st, 2018 false allegation. The only false allegation on May 21st, 2018 is that Hammond was masturbating in the steam room. That's throughout, and that's what's defined at the very beginning of the complaint. If I may continue, Your Honors, on complaint 102 at the record 43, we reiterate that same false statement was reiterated to Kathy Ann Boniello of the New York Post. She then ran a story with the headline, "Lawyer accused of masturbating in the gym while staring at the employee." And to Justice Friedman's point, you need to look at the next paragraph and then see that August 25th, 2018 story identified Hammond by his name, his profession, and his employer. Next paragraph, complaint 105, record 44. The same article provided a detailed statement, including the false allegation, and it was attributed to an Equinox staffer, then identified in the complaint as Alexander. 107, this similar story ran a few days later, reiterating the press statements, again attributed to Alexander, but not with a picture of Hammond. If I might just finish on one point, Your Honors, on this issue.
You have time on rebuttal.
Thank you, Your Honor.
Okay, thank you, Your Honors. I'll be very brief. The first issue I would just want to bring up is that the Sagali versus Carrega case decided by the First Department addresses the issue that the fact that it is alleged that a statement to the police is alleged to be false in itself does not constitute actual malice. So that's just to put the period on the first discussion. And the second is just to say that Hammond's attempt to consolidate a bunch of these different allegations, very few of which actually mention anything that Alexander quoted, doesn't satisfy the special pleading requirements for a defamation case under CPLR 3016A. Most of them don't even involve him, and almost all of them are on information and belief. Hammond could have included the articles, which might have shown precisely what he was quoted as saying, or might have set up a defamation claim against the New York Post, but he chose not to do those things.
Let me just ask, are you acknowledging that if it was pled better, it would be sufficient, that if he had actually said more specifically he lied when he made the statements to the New York Post and he lied when he made the statements to the police, then he would have made out viable defamation claims?
No, it would have been better, but it would not have made out a case for defamation for the common interest exception, and because still most of the allegations don't actually refer to Alexander, and they don't target Hammond. Thank you.
Your Honor, so I might call your attention again to a different case that also involved defamation. Pappalardo, it's in our briefs. The reason for the requirement of specific pleading in defamation cases is to give adequate notice to the defendant as to the occurrence constituting the wrong and discourage the institution of vexatious actions. And it also goes on to quote Foley v. D'Agostino from this
Also,
court.
how do you get around Corrego?
The answer in this case, Your Honor, is very simply that the false allegation is almost virtually a defined term in this complaint. And so it's specifically alleged in that regard. And yes, it could have been wrongfully pleaded. There's no doubt about that. But there is also no doubt that the complaint says that Alexander made these same false allegations to the police, but more importantly, in this case, to Ms. Boniello.
Does Corrego stand for the proposition that just claiming that the allegations are false is insufficient to establish malice?
No, Your Honor, I think, Brio, the case that we cite in our brief, aside from the fact that that specifically talked to falsity and known falsity, at least on a motion to dismiss, is sufficient to demonstrate malice, to overcome any asserted privilege in this case. But one, final point, Your Honor, as to the press, there's also, if you read the entirety of the complaint, yes, and so maybe he should have had the right to replead this matter, but the fact of the matter is, you look at it in the entirety, Hammond complained that Alexander made a false allegation that he was masturbating in a steam room. The complaint says he made that to Equinox. The complaint says that it ended up in the Post because of the unnamed source, which we say was Alexander, and that's clearly in the complaint. That's not disputed. We reference another complaint in this, that Alexander made these same...
You asked to replead?
No, Your
The
Honor.
event it was found to be inadequate?
No, Your Honor, but that should always be an option, but no, it was not specifically done below. You're correct, and that's what I'm saying. But we also referenced the Alexander's complaint against Equinox in this, and in that complaint, as Alexander well knows, because the standard here is to put the defendant, in this case, on notice of the claims. Alexander knew exactly what allegation was being talked about. He actually says in their papers, they admit, hey, that was not the worst he said. He said much worse about Hammond. So clearly he knew exactly what he was talking about here. He has a separate complaint against Equinox on the same basis. It was related in this complaint.
Thank you.
Alexander knew. Thank you, Your Honors.